Australia's endangered wildlife has just received greater protections after a federal court case. Sam Szoke-Burke from the Wilderness Society was part of the team that took on the federal government, and he joins us on the couch now. Sam, welcome to the program.
Great to be here.
So I think we need some context around this, first of all. Endangered species get a plan to help them recover, essentially. But your concern, I think I'm right in saying, has been that there's been this backlog of plans that's been mounting and mounting and mounting, and not a lot's been happening.
That's right. We took legal action against the Federal Environment Minister because we were concerned that there were a number of species that were hanging in the balance without a plan, despite it being legally required. So those species include really wonderful oddities like the greater glider, which is a kind of flying rectangle, a kind of possum that can glide up to 100 metres in the canopies of the forest. The way these plans work, we kind of refer to them as recovery roadmaps for species. So species that are put at threat, often because of habitat destruction. The minister will make a decision that a plan is required, and then he has 3 years to make plans. Some of the species in this case have been waiting since 2009 for their plans, so clearly overdue, and we frustratingly felt that we had no course but to issue legal proceedings to make sure that these plans were actually put in place.
So you often see a minister jump up and say, right, I'm protecting this, I'm going to announce a plan, this is going to happen. It then sort of sits there. Does that mean that if the plan's not implemented, there's not really those mechanisms to protect from new development, maybe to protect from a different habitat destruction, invasive species baiting, things like that?
Implementation and funding are both really important, especially to put the species back on recovery. But even the mere existence of the plan is going to be important for the government, because the minister cannot act inconsistently if a plan exists. So that means that if they're considering a destructive project in a forest, if the greater glider had a plan, the minister can't act inconsistently with that. So the mere existence of it is really important, and that was what we were litigating about, the fact that these plans simply didn't exist.
So how much of a difference do you think this court decision and this court win for you could make?
I think it's a really important step forward. We are actually using the courts now to get the government just to do its job, to do what the environment law says, which I don't think is a very high bar for the Environment Minister. We've got a commitment now that the plans will be made for 4 species by July next year. But the other important part of this settlement is that the Environment Minister has now changed his position about older plans. Previously, the government operated on the basis that those plans expire after a certain amount of time. After this litigation, the new position is now that those plans act forever, and that's now protection for hundreds of species that were previously didn't have that certainty.
Photogenic animals, particularly in Australia, always get a lot of attention. They get funding, they get tourists. What are some of the other less photogenic animals that are going to be protected in this way? Because there is, of course, so many different animals in Australia that are endangered for a variety of reasons.
Yep, I can talk about 2 really different types of fish who are also featured in our case. One is the Australian lungfish found up in Queensland, and that's a scientific oddity that's kind of linked to the evolution of species that crawled out of the water and started to become land-based species. It has a lung, so it can breathe air through 5 sets of gills, and there's one species that was transported over to the US in the 1930s, a lungfish that's still alive to this day, living in an aquarium on the west coast.
Wow.
Another very strange but scientifically important species is the Australian grayling, which is sometimes referred to as the cucumber mullet because it can give off a cucumber smell when handled. And that species is really not well known, but spawns in fresh water. Its eggs go out to sea, the hatchlings hatch, and then it swims back out of the seawater back up into the freshwater system. These are species that are smashed by land clearing, by sediment runoff. And so it's really important that they actually have those protections and that the governments are making coherent decisions based on the best available science. And you can't do that if you don't have those recovery plans in place.
Just before we let you go, I wanted to ask about the biggest threats to some of our native animals. We speak a lot about climate change on this program. How worrying are invasive species at the moment, which just seem to be spreading and spreading and spreading?
It's a big threat. Another big threat that we really focus on is deforestation. So native forest logging, but also agriculture-driven land clearing. The Environment Minister is embarking on law reforms to the federal law right now, and it's crucial that deforestation loopholes in those laws are actually finally closed. That's what our supporters have been mobilising all around Australia for, and that's what we'll be watching really closely as those reforms proceed.
Okay, Sam, thank you very much for joining us this morning. We appreciate it.
Thanks for having me.